Welcome to Conflict to Clarity in Family Matters with Rahul Kishore.
Welcome back to Conflict with Clarity in Family Matters with Rahul Kishore. Rahul is a Maryland family law attorney at Shaw and Kishore with more than 30 years of experience helping individuals navigate divorce, custody, and complex financial issues. With a background in finance and an MBA, he takes a practical, cost-effective approach to resolving family law matters. I'm Leann Lyon, and today we are talking about alimony in Maryland, including how courts decide whether it's awarded, how long it lasts, and what factors matter most. Rahul, how is alimony determined in Maryland divorce?
Good afternoon. Thank you for having me. Alimony, interesting in Maryland, is not based on a formula. Like child support is based on a formula. Alimony has many factors that the court looks at, from the age of the parties to the educational level of the parties, from how long they've been married, to how much each party's income is, whether one party has been working throughout the marriage, whether when you get a divorce in Maryland, how the property is divided, how much each party has in retirement, and how many assets they'll have, including the retirement, after the divorce, and whether the standard of living the parties had during the marriage will affect their ability after the marriage. Also, another factor is how much we can bring each party back to. If one party's not been working, whether that party can be brought back into the workforce, and how much income that party would make if she has not been working, or whether she's been working part-time and needs to get what we call rehabilitated back into the workforce. These are all factors. So you have to have a lot of experience in the court system here in Maryland for us to give you a great viewpoint on how the court's going to view it in your particular situation.
So to reiterate, you said that Maryland does not use a formula in alimony, correct?
Correct.
Okay. So what types of alimony then are available in Maryland, and how do they differ?
The first type of alimony you have is what we call rehabilitative alimony. Rehabilitative alimony is when you get it for a short period of time. It's normally when it's only for the purpose to get one of the spouses back on their feet and to rehabilitate them back into the workforce to be self-supporting, okay, or be able to live a standard of living that they had during the marriage. Now, if you have a short marriage, let's say less than 8 to 10 years, you're probably only going to get rehabilitative alimony. But what's interesting is if your age is, let's say, 55 and above, then you may be able to get the other type of alimony, which is what we call permanent alimony. Permanent alimony, on the other hand, is normally given to a couple that's been married a long time. One of the parties has not been working, or has been working but part-time, or there's a huge disparity of income, or the educational levels of the parties is disparate, and they've had a long marriage. Then the spouse that's going to receive the alimony is going to get what we call permanent alimony. And permanent alimony in Maryland is till it goes on afterwards until one party dies, which is the party receiving the alimony, or the party paying it dies, or the third way is if the party receiving it remarries. Those are three basic ways that alimony terminates in a permanent alimony situation. The third type of alimony, which is what we call Pendente Lite alimony. Pendente Lite means pending litigation. And what that means is during the divorce case, which in Maryland can take from 6 months to over a year, depending on the complexity of the case, the alimony that you can get granted by the court on a temporary basis during the litigation until the final divorce case, and at that point is when they decide if you're going to get the rehabilitative or the permanent alimony, during just that short period of time during the litigation, the court can grant the spouse that needs the alimony Pendente Lite alimony. Those are basically the three types of alimony that are granted in a Maryland divorce.
So, how do differences in income between the spouses really influence the alimony decisions?
Well, that is one of out of all the factors I gave you, the alimony factor that's most prevalent is the income. If there is a huge disparity of income, which also causes the standard of living between the parties to be a lot different after the marriage, the longer the marriage was, the longer the party that needs the alimony would get the alimony, the rehabilitative or the permanent, based on the income disparity. So one of the biggest factors out of all of it is to see what the income levels of the parties are and what they can afford. So when we analyze alimony, we do what we call a long form financial statement that's filed in a divorce case. And the court looks at that and analyzes the income after, all the taxes and other deductions. And then they look at each party's what we call the long form financial statements. And that's one of the biggest factors the court looks at to determine whether alimony is going to be granted, actually.
In the case of one spouse having left the workforce, it seems like it would be very complicated. I mean, they've been living on one income for a time at least, and yet when the house is divided, maybe there's two households. How common is it for people to really truly be able to keep their level of living that they've been used to, or do typically both sides have to concede a little bit?
To answer the question, it's both. One is the party that has to pay the alimony is going to strongly, if I'm representing them, try to see if the party that hasn't been working can get rehabilitated back into the workforce. We as divorce attorneys hire what we call rehabilitative professionals who can review the ability of that party to get back based on the educational level, based on what experience that they've had throughout their life in the workforce, and what training we can get them to get back into the workforce. So each party hires a rehabilitative coordinator professional that we hire, and each party will try to show to the court that this party can start making money in a certain amount of time to get back in and be self-sufficient. Because in Maryland, alimony is only given if you are not able to be self-sufficient. But if you can prove that the party can be self-sufficient and be able to take care of themselves, then the alimony argument becomes much weaker. So to answer the question, there will have to be, if it's somebody who is, their age is, let's say, over 50, it's hard to rehabilitate them. Their health is bad. Health is another factor that the court looks at for an alimony factor to determine alimony. If the health isn't good and you can't get that person to go back into the workforce, then it will become complicated, and it will involve the party's income or the generation of the income to be split somewhat if they get divorced. And that's where people have to make hard decisions about keeping assets, selling assets, distributing retirement accounts. And that's why a divorce and having a professional who has a strong finance background, which I have an MBA as well, that we can maneuver these types of things and be able to give a stable environment and stable, future to both spouses, and negotiate that through sometimes mediation, because I'm a mediator as well.
Wow, you have a lot of hats. That's a
Yeah,
benefit to the people that work with you, I'm sure.
yeah. And I am fortunate, and that's why our practice has been able to get a diverse group of clients. I represent about 50-50 women and men, and my practice also involves younger people, next gen, and we also represent people who are much older and going through a divorce, which we call a gray divorce. So I represent people in a spectrum of divorce arenas, and we represent a lot of people that own businesses, and we also do complicated custody cases. So I do a huge, diverse divorce practice over my career.
It sounds like, especially when a couple is looking towards even the potential of alimony, that becomes more or less a don't do it yourself type of divorce. Am I right?
Oh, definitely. Because, like I said, in Maryland, we look at the long form financial statement, the complexities of drafting that a document up, and being able to maneuver and explain the actual expenses that a person incurs on a monthly basis. There's so many expenses that people don't understand how to put down, how to look at all the income, especially if there's somebody owns a business. We have to capture all the income depending on who you're representing, and to show the court whether the alimony claim has a validity or not.
Is it true that the more complex the divorce, including alimony, the likelihood that it's going to take longer?
Yes. And what I want to stress to you is that it costs a lot more money in legal fees, but my law firm and what we stress is we try to bring these parties down and sit down and do mediation as quickly as possible. This is one thing that is a lot different than other attorneys that practice here. I encourage mediation, and when you have complex situations where alimony is involved, we can bring in experts to give advice. We can use that advice in mediation and come up with solutions which bring into the factor of the asset, how a specific asset is distributed to generate income, whether specific retirements accounts are going to be distributed, or if there's a pension involved. We can look at the income flow and the assets that each party gets. And it is very important when you're going through this big change in your life to make sure that you come out on the other end in a stable environment, emotionally, physically, mentally, in every other aspect. So that's what we try to do for our clients.
So important. The whole person approach, correct?
Yes, yes.
Yeah. So here's a question. Can alimony be modified after a divorce? And if so,
Yes.
what typically needs to change to make that happen?
Okay, so alimony there's a lot of agreements that we do, ma'am, and this is for depending on who you're representing. We do a lot of cases where it's called non-modifiable alimony. So if you're negotiating in a case, what we do is we try to, like, let's say if somebody's going to they're supposed to get 3 years, but the person you're representing doesn't want a situation where it's modifiable, so he'll agree to pay 5 years. If it's non-modifiable based on an agreement that we came to, then you can go in and ask for modification. But if it is usually determined by the court through a litigated case, the court determines if you get rehabilitative, if you get permanent. Normally, those are modifiable, okay? And they're only modifiable, ma'am, if you have what we call substantial change in circumstances. If one party retires, one party has a disability, one party's income dramatically goes down after the alimony decision, or one party's income dramatically goes up, these are all factors that lead to a modifiable alimony case.
Can you share a story where maybe the parties were headed towards one form of alimony? You mentioned that there's three, and then abruptly changed course and ended up going a different direction, and why?
Well, if you're litigating a case, normally an attorney will request both rehabilitative and permanent. And in a situation where we're doing litigation and we're going through discovery, that situation may occur. And the line between rehabilitative and permanent, normally you can see the line in the sand, but at certain situations, you can go to court and argue that you want permanent, but the court would only give you rehabilitative and vice versa. But normally, if you're only asking for rehabilitative, the court's not going to give you permanent. But it is the definition between rehabilitative and permanent depends on rehabilitative is for a certain period of time, and it usually terminates for a shorter period of time from 3 to 7 years. But permanent is till like the three factors I gave you, which is either party dying or one party who's receiving it, gets remarried.
Well, as we wrap up today's episode, what should somebody do early in a divorce if alimony is likely to be an issue?
Very good question. Like I was stressing earlier, the long form financial statement is very important. So if you are looking for an alimony claim, you need to sit down, look at your income, look at your assets, and look in detail of what your needs are, okay, and what your ability to work and what is your health. So all of these factors are important. So if you're looking for alimony, the biggest thing is to figure out what your expenses are and what money you have coming in if you're working. And what if you're not working, try to figure out what your historical expenses have been, what your standard of living has been, and have all those figures and information available, because that'll make your case stronger for an alimony claim.
Excellent point. Thank you so much. And to our audience, thank you for listening to Conflict with Clarity in Family Matters with Rahul Kishore. If you have questions about alimony or other financial issues in a Maryland divorce, Rahul Kishore and his team at Shaw and Kishore can help you understand your options and plan your next steps. Visit maryland-lawoffice.com to learn more and schedule a consultation. And remember to like, leave a review, and subscribe to the show so you catch every episode. Thank you, Rahul.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.